Hello, it's Christine Faulkner with Cava&Faulkner, Elk Grove Living Trust Lawyer, Sacramento Estate Lawyer. Thanks for tuning in to another edition of The Daily with Christine. Hey, business owners, do you know what your business documents say with respect to your ability to transfer your ownership interest? So if you have a corporation, your shares, or if you have an LLC, your membership interest, do you know what your bylaws say regarding that in your corporate documents or your operating agreement in your LLC? Good to know. So stay tuned to this video because we're going to talk about what your corporate and LLC documents say can affect your ability to transition your business, and how you can make sure that your business is protected in conjunction with your estate planning. So let's get started. So perhaps you have an S Corp or you have a C Corp, you have a corporation. Well, many of my clients don't really know what that means in terms of their ownership interest. They know that they have this entity, and they know it's a corporation. They may have set it up by a recommendation from their accountant for tax purposes. And so I want to go into a little bit about the legal side of it and why it's a great thing to have from an asset protection perspective and just how that works. But then I also want to talk about how there's that crossover between your corporation or your LLC, your business entity, and your estate plan to effectuate your wishes, which is possibly to transition your business onto your loved ones and making sure that you have everything locked down correctly to do that. So do you ever wonder about this? Do you wonder what would happen to your business, your corporation, or your LLC if something happened to you? Did you ever look to familiarize yourself with your bylaws in your corporate binder or your membership operating agreement in your LLC binder to see, well, how does that happen? Is there anything about what happens if I die? Is there anything about what happens if I become incapacitated? If not, not a great thing, right? You want to have a plan where people can jump into action and know exactly what the next step is. So that's the first place that I recommend my clients look. Go into your bylaws, go into your LLC operating agreement and look for that language. What does it say happens if you become incapacitated? Is there another member who can step in? Is there another person who has a power of attorney who can step in and operate your business for you? What happens if you pass away? How does that happen? Does it go to your estate? If you see language in your operating agreement or your bylaws that says your interest goes to your estate, that's a really bad thing. You don't want it to go to your estate. You want it to go to people, not an estate, because if you have an estate, it means you're probably going to end up going to court. So just remember that. I know people think estate, that means I have something. That means I have a lot. Well, yes and no. I mean, having an estate in terms of having assets that are worth something is a great thing, but in the legal world, having an estate that you leave behind is not what you want. You want to have a mechanism to pass your estate, your assets, to the people that you love the most in your life, either through a trust, a beneficiary designation, or a business entity. So that's why I'm suggesting you first start by looking at your bylaws or your operating agreement to see what it says there. If it doesn't say anything, if it's silent, that's a red flag. So now you've looked at your documents and you're wondering, what's my next step? It doesn't say anything. Well, I think, many feelings that my clients express are dismay and concern for sure. That feeling of like, oh my gosh, I don't know the answer to this question and that feels really bad. I need to know that I have this puzzle, all of the pieces put together so that there's going to be a smooth transition, and not just that there will be a smooth transition, but I know how it works. There's that uneasy feeling that people have, like, I don't even know. Have you ever felt that? If you have, I definitely can relate. Something that my clients express often. So Great starting point. Okay, so your documents are silent. Now what do you do? Well, you probably want to figure out whether you need to go back to a lawyer if you worked with a lawyer, or if not, maybe you want to work with a lawyer to get that tied up in your actual documents itself. But in terms of the succession planning, in other words, what happens to your business if you pass away, right, or become incapacitated, probably want to seek counsel with an experienced lawyer who can give you really solid advice about the interrelationship between your business documents and your estate planning. So let's say you need a trust, and many times people do. They need a trust to avoid probate, that icky court process that takes a lot of time and costs a lot of money, and ties up your assets for a period of time. So many people want to avoid that. They want to make things really easy and quick for their family. And so when I'm working with people who have businesses, we talk about the fact that when you create an estate plan, there has to be a mechanism either in your business to transition your business or within your estate plan. And so if there's nothing in your business documents, then probably something you want to build into your estate plan. And one of the ways that we do that is by creating a plan that outlines your distribution, meaning who gets what, when. So if you're married, many times that would be, if you pass away, that would be your spouse would get your assets. Not going to go into some more complicated design methods, but just real simply, your spouse gets what you have. And then after your spouse passes away, then your children or your beneficiaries, whoever they may be. So when you create a trust, the way that you integrate the trust with your business entity is you assign the value of your business entity into your trust. So for a corporation, that is your stock ownership, right? So your monetary interest in the business, the value is actually held in your stock ownership. And so you can assign your stock ownership to the trust. You can do the same thing with your LLC membership interest. You can assign your membership interest into the trust. This is a pretty streamlined and simplified analysis of what you can do. Many times it's way more complicated because if you're in business with people other than your immediate family, maybe there's some other succession planning that you want to look into. Because sometimes when you put your interest into a trust and you pass away, it could end up that your spouse or your kids end up in business with your existing partner. And many times that's not exactly what people envision, having new shareholders that were not the original owners of the business. So there's definitely some ways to handle that, and sometimes it's through the actual business entity itself versus the trust. So there's lots of different ways to skin a cat, as they say, but I wanted to do a quick video about, the interrelationship between business ownership and succession planning and trust planning and estate planning. But I want to just say this in closing. Regardless of the tax benefits that you may receive from having a business entity, one of the great and wonderful things about having an LLC or a corporation is the asset protection it provides to you. And so to be really clear, having a corporation or an LLC protects your personal assets from any litigation or creditors against the business or malfeasance committed against the business. So if you have a business and your business is sued, assuming the appropriate formalities have been kept up in your business, your personal assets are protected from that litigation. The recovery is limited to whatever the business assets are. So it's a really nice asset protection strategy, as well as giving you some probable tax advantages. But the thing that you need to remember about this, which is so important and basic in law school, basic tenet in law school, piercing the corporate veil, right? So think of the corporation as a container, right? A closed container. And how do you pry it open? How do you get into it and get beyond those protections to get to the principals and all of their personal stuff? Well, you pierce the corporate veil. And one of the easiest ways to do that is to basically argue that the corporate formalities are not being kept up. So you have to go back to that operating agreement. You have to go back to your corporate bylaws and look at what is required for maintenance and upkeep of this entity. Maybe it is having an annual meeting with written minutes that are recorded in a book, issuing actual shares, allowing shareholders to come in and look at this, the corporate books at a specific location. So I have a lot of clients who tend to disregard the formalities of the entity. They don't have those meetings. They don't do what is actually laid out in their own bylaws. And so that is where that wiggle room comes in. And if you get sued, if your business gets sued and you can't show that you've kept up those corporate formalities, they could actually pierce the corporate veil and get to the individual principals or owners of the business and also to their individual personal assets. So super important that you know what your bylaws require you to do and that you be doing them and you have evidence of it. And the same thing is true of your operating agreement. Many times people choose LLCs because they're very they're less formal. They don't require, issuing actual shares, and they're a less formal entity. They allow people to run a business in a very flexible way without being required to have, annual meetings, blah, blah, blah. But to the extent that there are formalities that have to be observed, they have to be observed. And you better be able to prove that you have observed them, or the corporate veil or the LLC veil could be pierced. LLC is a little bit of a different animal, but nevertheless, for purposes of this discussion today, could be pierced and you could lose all of that asset protection. So moral of the story today, get familiar with what's in your bylaws or what's in your LLC operating agreement. If you don't know what any of that means, we can definitely help you with that. Give us a call. We're here to help. And if there's anything that we can do to help you have a better or clearer understanding, we're happy to do that. If you feel like you need to actually make a move and really gain deeper clarity, have us assist you with any of this, we are absolutely available to do that with you. So just let us know, give us a call, email us, tell us how we can help you. Thanks so much for tuning into the Daily with Christine. Loving it out here in the sunshine. I hope you guys are having a great day, and take care. We'll see you soon. Bye-bye.